Hello, this is Matt on the Moon Lambeau channel. Today, a congressman wrote a letter to Kim Gensler, and I absolutely love this because, look, this particular congressman isn't even asking Gensler to respond or do anything. He's basically just throwing the great news of the ruling from Judge Torres in the SEC v. Ripple case in Kim Gensler's face. He's just throwing the ruling in Gensler's face, which I rather enjoy. It's fantastic to see. And he also states some ways in which, he hopes the SEC will ultimately change. But this is a letter that isn't, honestly, you'll see as I go through it, this is why I loved it so much. Like, it's not even seeking to do anything. It's just satisfying. If you're an XRP holder, you're just going to find it satisfying. And I shouldn't say that it's literally going to do nothing, because this is the type of thing that can sway public sentiment, and this is circulating widely on social media, and I actually do believe that is something that matters. But in terms of it, impacting Gary Gensler himself, in theory, maybe. I'm not exactly confident, but big picture, yeah. I love this stuff. So I'm gonna share with you the specifics. This is gonna be a fun one. But before going further, I do want to be clear. I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, I wanted to highlight something real quick before jumping into that. You can see there's a headline on your screen from the Crypto Basic. Top lawyer mocks Max Keiser as XRP receives clarity. Max Keiser, gigantic Bitcoin maximalist, highly toxic. It's the opposite of the type of person that you would want involved in crypto, because it just makes us all look like a bunch of damn fools. But, there are some Bitcoiners that are just like that, and he's toxic. And so he tweeted out on June 10th, a little over a month before this most crucial ruling, which is very good for XRP and XRP holders. Max Keiser wrote, "Deaton will advocate tirelessly for his clients, but he must know in his heart of hearts that XRP is a dead coin walking." And there you go, that tweet aging like a, like a fine milk. Yes, that tweet is aging like a fine milk. And so that was retweeted by attorney Bill Morgan, who said, "This hasn't aged well over the last 5 weeks. Not only is XRP not a dead coin walking, but a judge found that the XRP token itself is not a security. Bitcoin no longer has a monopoly on clarity." Oh no. Yeah, so this is not what Max Keiser wanted or thought would actually happen, but like it or not, it's actually the case that XRP is the only cryptocurrency that's a large cap coin that has clarity. Bitcoin technically doesn't, so attorney Morgan here said Bitcoin no longer has a monopoly on clarity. So obviously, technically, the SEC hasn't ruled on it, but it's being treated as such, even by Kim Gensler. So it does appear pretty damn untouchable at this point. I'm just saying from a technical perspective, we're not seeing this. And I wanted to mention also, so, and this is something, I haven't heard anyone else quite say this, but what I find so interesting and satisfying, regarding the outcome of this SEC v. Ripple case, is that the SEC screwed themselves by reaching too far. Judge Torres did not have to speak out about whether or not XRP itself is a security, because that's not a question that she was tasked to rule on. So she didn't have to say anything about what XRP is or isn't. And truth be told, most attorneys that I followed anyway did not think that Judge Torres would broach the subject at all. But she did. But why? Why did she do the thing that most attorneys didn't think she'd do? Why would she cite that XRP is not a security ultimately? Well, because the SEC put forth what has become known as the embodiment theory, which effectively asserts that XRP itself is a security. Now, that is such a big claim, if true, and it would impact other facets of Judge Torres' decision-making process on matters she was tasked to rule on. So as a result, Judge Torres clearly felt obligated to speak on the SEC's embodiment theory, they brought it up, which resulted in her ruling ultimately that XRP itself is not a security. So think about this. Had the SEC not overreached the way it did, effectively arguing that the token itself is the security because it embodies all the efforts of Ripple, so on and so forth, blah, 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 blah. Well, had the SEC not overreached, had they not put forth this bogus embodiment theory claiming that XRP itself is the security, then Judge Torres almost certainly would not have spoken on the topic at all. we would not have legal clarity for XRP. What I'm saying is that the fact that the SEC so heinously overreached and disgustingly sought to make up law as they went along is what made it possible and reasonable for Judge Torres to rule the way that she ultimately did, finding XRP to not be a security. The SEC did it to themselves. How satisfying is that? Very, I'd say. Well, things about to get even more satisfying. Check this out. There's a tweet from Rep. Richie Torres, and the last name that Torres there, that's just a coincidence so far as I'm aware anyway. But this is the congressman, sitting congressman, who wrote the letter to Kim Jong-Gensler. And I always say credit where it's due. I always cite on my channel. I will only speak on politics insofar as it pertains specifically to crypto or finance, because if the second politicians start talking about crypto or finance, they're coming to my turf, all right? But I'm not going to be opining on general political matters. This is not a political channel, and it absolutely never will be. I'm never going to be preaching to you about anything outside of, in terms of politics, I don't want to be touching anything political unless it has to do with crypto or finance. But again, it's only political if they come to us and start doing it. And so I just wanted to highlight, I will praise whether it's a Democrat or Republican, somebody on the left or the right. I don't care. If you're doing the right thing, I'm going to highlight you. And if you're not, I'm going to call you out. And so here you have a Democrat congressman, Rep. Richie Torres, who is doing the right thing. He seems to be squarely in the corner of XRP holders. So thank you very much, Rep. Richie Torres. Couldn't be more thankful that we got another individual that's clearly on our side. And so he shared the letter, which I'm going to run through in just a second. And this was retweeted by Warren Davidson, who happens to be a Republican. And so what state? I always forget what state he's in. It's probably listed in his profile here. Oh, maybe it's not listed. But anyway, so he's also in Congress. But anyway, he tweeted out the following: I joined my colleague in calling for Gary Gensler to embrace a different approach. The Ripple case should make clear that Congress needs to provide clarity that is lacking for investors, innovators, regulators, and even the courts. I remain hopeful that we can agree on a digital asset market structure bill that will do this appropriately and swiftly. So there you go. I don't care if you're on the left or the right. If you're doing the right thing, I'm going to say it. And if you're not, then I'm going to say that too. Attorney James Murphy, known as Meta Lawman, responded to Warren Davidson and said, Warren Davidson, oh, there it is. Yeah, I did have it here. A Republican, Ohio, retweeting Richie Torres, Democrat, New York. Maybe there's hope for sensible crypto legislation after all. Oh, kumbaya, let's sit around the campfire. But he's got a point, especially with the way things are going. I'm going to have to expand upon this further in videos in the future. But there are things unfolding. And if you just look at the response broadly, what's happening with this administration that's just been very anti-crypto, it's fascinating. And it might have created an opening with the decision from Judge Torres. But I'll talk more about that in a separate video. Then there was Paul Graywall, who is a chief legal officer with Coinbase, and he tweeted out the Torres Doctrine, which is what's cited here from Rep. Richie Torres, a remarkably cogent summary of Judge Torres's jurisprudence from Representative Torres. Thank you, Congressman. Here you have a tweet from Attorney Bill Morgan. What you call the Torres Doctrine is the part of the decision that will stand no matter what the SEC does. It is consistent with many cases that followed Howie that the judge cited. Yep, couldn't agree with that more fervently. And so this idea of XRP not being a security, obviously true, that's not going to somehow magically be overturned. And so here is what Rep. Richie Torres wrote to Kim Jong-Gensler today, and it is glorious. It reads as follows. Dear Chair Gensler, and again, that's just, if I could just read it, I love it, and it's hilarious because he's not asking Gensler for anything, it's just throwing it in his face, and it is satisfying. I'm just saying. So he says, Dear Chair Gensler, I am writing to inquire if the SEC intends to come to terms with the folly of the Commission's crusade against crypto assets in light of the latest decision by Judge Annalisa Torres of the Southern District of New York. Needless to say, regulation by enforcement had a dreadful day in court. Ain't that the damn truth? So, Gary Gensler, I'm writing to find out, do you know about how severely the SEC lost? I love it. He's not asking for anything. And then he says, in a landmark legal opinion, Judge Torres resoundingly rejected the regulatory overreach of the SEC, which has been indiscriminately declaring all crypto assets except Bitcoin to be securities. By emphasizing the need to prove the presence of an investment contract, Judge Torres's reasoning represents a return to a rigorous application of the Howey test, which has been applied sloppily by the SEC. True words never spoken, damn it. Absolutely, the embodiment theory. The embodiment theory. The asset itself represents the efforts of Ripple. Where the hell is that in Howey? Go back to the Howey decision in 1946 from SCOTUS. You ain't sconce to find it. Yeah, sloppily. I like that he said it because that's quite the dig, but truth be told, it's actually much worse than that. I think that there's just malicious intent. But still, I'll take sloppily. I will take sloppily. Anyway, he continues. Indeed, the latest court decision establishes a clear rule that should bear the name of Judge Torres, who has brought long overdue legal clarity to the chaos of crypto regulation. The Torres Doctrine, as I call it, holds that crypto assets are not securities in themselves, but can be sold as part of investment contracts, which do qualify as securities under the Howey test. Judge Torres has made it crystal clear to the SEC that digital assets are not securities in the abstract, and that it lacks the legal authority to regulate digital assets untethered from an actual security offering. Even though the SEC reserves the right to appeal the district court's decision, the chances of an immediate appeal are vanishingly small because there remain issues in the case that have yet to be resolved, and resolving them requires fact-finding, i.e. a trial, which takes time. Yeah, so I'll pause and note, technically there could be not just an appeal request, but like an acceptance of the appeal. I just think the probability is exceedingly low. That would be the whole, talking about this recently, what's the term? Interlocutory appeal, I think that's the term. I think I said that right anyway. I'm not an attorney, I just play one on YouTube. So interlocutory appeal, that would be the type of appeal that you can request when it would, be before the time where it would normally be reasonable to do so, because, as cited here by the representative, there's still a trial yet ahead. That needs to take place, and normally, after all that's said and done, then you could place the appeal. But this just means interlocutory appeal. Just think, it just means like opportunity for special appeal. The judge would have to approve it. Judge Torres would have to approve it. And typically those things are only approved if you can show that there is something that was just dramatically taken out of context. There's a context or a huge piece that was missed or something misunderstood there. Basically, you'd have to show that there were major mishap and the judge would have to agree. So the odds of that very low. I think the judge is pretty confident in her decision here. So no, ain't gonna happen in all likelihood. Very low probability. Anyway, then the representative continues. The ability of the SEC to make up the law as it goes along will be, in the meantime, constrained by the persuasive authority that the Torres Doctrine will likely command in future legal cases. The tenuous legal foundation for the litigation against Coinbase has come crashing down, and rightfully so. In addition to issuing findings of law, Judge Torres made a point of faulting the SEC for conspicuously failing to provide fair notice to the crypto industry. Under Chair Gensler, the SEC has not issued a single rule on crypto assets, nor has it given any clear guidance. All it has done is sent mixed messages, one after the another, he means one after the other, but not only contradicting the CFTC, but often contradicting itself. When pressed about the status of Ether as a security, Chair Gensler has been all over the place. Yes, no, maybe so. The SEC has chosen to communicate and regulate not by clear rule or guidance, but by enforcement actions, often politically timed. The endless stream of contradiction and confusion, as well as the arbitrariness of the enforcement actions themselves, is the opposite of fair notice. Now, pause to think about this. Here you have a Democrat saying that decisions from this administration, which, let's be real, I mean, you're talking about the Biden administration. He's the one that wanted to have Gensler in charge. He got it. He's talking about political timing here, and that's politically the side that he's on. Kudos to him for calling this out, because this administration is absolutely anti-crypto and against us. That just broadly speaking, I think that's very clear. If you're being intellectually honest, it'd be hard to disagree with that, I think. And that's why I'll call it anybody. And I also make clear, it's not about being on the left or the right. It's about who's doing right and who's doing wrong. I think the previous administration did an awful job also. It's just amazing. Biden was like, hold my beer, and then did it even worse. But anyway, so I was just saying kudos to him for actually stating something like that. And then he says, I hope that the SEC will find itself so chastened by the court's decision that it will concentrate the commission's enforcement energies where it belongs, on the bona fide bad actors who perpetrate serious transgressions like fraud, market manipulation, and the misappropriation of customer funds. I look forward to finding out how the SEC will reassess its regulatory assault on crypto assets in light of the Torres doctrine. And then he signed. That's it. I love it. Because it's basically like, you suck, Gensler, you lost, I'm throwing it in your face, now how you gonna act? That's pretty much it. Now how you gonna act? I love it. It's fantastic. You'll love to see it coming straight from Congress. And again, in a coming up video soon, I don't know if it'll be today, maybe, probably tomorrow, I think. I really want to dig into like the implications of this, because you suddenly see like some of it's silence. Like, I'll say this, some of it's just like this concept of deafening silence. Like, it's so noticeable that some of the clamoring and pontificating from people in places of power in that administration, it seems to have stopped temporarily. Well, that's kind of strange given the timing of what just happened. Might they be reassessing how to move forward? Good times. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.